there's nothing from him.
I know. Sir, you're the appellant, is that correct?
I'm Seyed Mohammad, Hadi Hosseini.
Okay. You are the other party to this lawsuit, is that correct?
Yeah.
And have you filed an appellate brief?
No, because I had no money, so for that reason I had no attorney, and I tried to come here by myself.
Okay. Well, unlike the trial court, if you have not filed an appellate brief, you do not have the opportunity to argue in front of this court. You're more than welcome to sit back in the gallery and listen, but unless you have filed a appellate brief, then you can't participate in the argument, okay?
Okay, so
Yes, sir.
How you can consider my unemployment situation? Because
None of that's before the court, I'm sorry. I understand that you have circumstances that you want to make us aware of, but the only thing in front of the court today is the appeal that the other side has submitted. And what your concerns may be should be addressed to the trial court. Okay? Thank you, sir. You're more than welcome to sit back there and listen to that. You're just not going to be allowed to participate. Thank you. Yes, sir. All right, you may proceed.
Thank you, Your Honor. May it please the court, my name is Elizabeth Walker Fike of the Shelby County Bar, and I represent the appellant Mahdieh Shabanian. This appeal presents fundamental legal questions about the enforceability of MAR provisions under Tennessee contract law and the proper application of alimony determinations. The outcome of this case will have significant implications for how Tennessee courts treat contracts that contain religious or cultural provisions. Today, I will address three key issues: the enforceability of the MAR provision in the parties' marriage contract as either a contract or, in the alternative, as a prenuptial agreement under Tennessee law. Secondly, the trial court's erroneous determination regarding alimony, which failed to properly apply statutory factors and resulted in an award that does not fairly compensate wife for her economic disadvantage. And lastly, the necessity of awarding attorney's fees due to husband's financial misconduct, which unnecessarily prolonged litigation and deprived wife of access to marital resources. The relief that we are seeking today is reversal of the trial court's ruling and enforcement of the MAR provision, modification of the alimony award to increase both the amount and the duration, and an award of attorney fees. Before I get into the legal arguments, Your Honors, I would like to provide a brief history of the MAR provisions. A MAR is a well-established—
Before you do that,
Yes, Your Honor.
Can you direct me to the trial court's reasoning in not enforcing this provision?
Your Honor, the courts, and I was not at the trial court, I did not represent my client at the trial court level, but it's my understanding—
That's not my question, though.
Yes, Your Honor. My understanding from reviewing the record is that the court found it unenforceable as a contract because it required the husband to pay money in order to get married, but that was not the case.
Where do we find that?
It is in the order that the court held. Well, it's not in the final decree, but it's in the transcript from the final hearing. Prior to the final hearing, there was a discussion that the court had with counsel about the MAR provision. Previously, it's my understanding, during the litigation, there were briefs that were submitted to the court about the enforceability of MAR provisions, and there was discussion in chambers with counsel and Judge Higgins about the enforceability of these provisions, and the court ruled in open court during the trial prior to the final hearing commencing that it was not enforceable as a contract or as a prenuptial agreement, and that's included in the final decree of divorce.
Okay.
So you said,
No, go ahead.
you said there was a discussion in chambers,
That is my understanding.
so there was no motion hearing in connection with enforcement of the Mars agreement where there's a transcript available for us to look at?
The transcript that is in the record does have Judge Higgins' analysis of this, of her decision, and that discussion is included in the brief that I submitted.
But not the argument that was made at the time of
Correct.
this motion or petition to enforce the Mars agreement?
Correct, Your Honor. The only proof that we have as far as argument is concerned are the memorandums of law that were submitted by counsel.
But that wouldn't be proof, though, would it?
Right, that's the only argument that was made. It was not made in open court.
So there was never an evidentiary hearing in regard to the Mars agreement?
That is my understanding.
So let me make sure I've got this correct. Was there a pretrial motion that caused this hearing? A motion to strike or deem it unenforceable?
I do believe that counsel for wife requested that the court rule on the enforceability of the MAR provision so that she could discuss it, or so that she could decide that at the final hearing. Instead of going forward and presenting proof at the final hearing, the court simply ruled that it was unenforceable.
And this reasoning that's contained in your brief, is it also contained in the record?
Yes, Your Honor, it's in the transcript.
Okay, and was that transcript made part of the final judgment?
No, Your Honor. The only thing that we have in the final decree is that the court said that the Islamic marriage certificate does not meet the requirements of prenuptial agreement, which requires agreements to have been entered into by the parties freely, knowledgeably, and in good faith, without exertion of duress or undue influence. And it further appears to the court that the parties' Islamic marriage contract is unenforceable as a contract because it is contrary to the public policy of the state of Tennessee. Therefore, the terms of the contract, specifically the MAR provision, cannot be enforced.
But there was never a hearing in regard to whether or not the agreement was entered into freely. Is that right?
That is my understanding. There was no testimony taken about the elements supporting either a prenuptial agreement or the contract.
How does that equate to the responsibility of the trial court under Rule 52 to make findings of fact and conclusions of law supporting whatever actions the trial court takes?
Well, Your Honor, that's what we're asking the court today to do. If the court does not, in fact, ask us, or does not reverse the trial court outright, then we are asking the court to remand this so that we can put on proof regarding the proper elements of a contract and or the proper elements of a prenuptial agreement.
So you are saying that it does not comport with Rule 52. Would that be accurate?
Correct, Your Honor.
Okay.
Let me ask you a question. You were reading from page 2 of the final decree.
Yes,
And the final decree uses the terminology Islamic marriage certificate.
Correct, Your Honor.
Is it your position that the word certificate there is actually erroneous and was actually referring to the contract itself?
Yes, Your Honor. The terminology kind of translates a little differently. The document is called a marriage certificate, but it is actually a contract. There is a written agreement that indicates what has been offered, what has been accepted, and the marriage is the consideration, and both parties signed that contract.
Okay, thank you.
As best I could determine from looking at the record, the only thing that the wife has attempted to enforce is what's described as a marriage portion, which requires payment upon demand of the gold bars The other section of this marriage certificate, which is called Other Conditions section, you're not attempting to enforce any of that, as I understand from reading the briefs anyway.
Correct, Your Honor. We're talking about two different areas of the law. We're talking about the state of Tennessee, and we're talking about Islamic civil law, which incorporates both governmental and the religious aspect of the Islamic traditions. So here we're talking about the state of Tennessee. Some of those conditions in there would comport with divorce law in Tennessee. However, what we are trying to enforce is the actual contract that states what was offered, what was accepted, and what was signed by both parties.
So other than the gold bars, what are you trying to enforce?
Your Honor, there are other items that were part of this contract. It included a volume of the Holy Quran, it included a mirror and a pair of candlesticks, and then the gold coins. And the gold coins were due payable to wife upon her demand. The MAR provision can have two different aspects. It can have an immediate aspect and it can have a deferred aspect. The immediate aspect was the Quran, the mirror, and the candlesticks. The deferred contract, or the deferred provision, was the gold coins. These types of contracts can include things as small as flowers, and it can include things as large as a residence or a holy trip in the Islamic tradition. But they can be composed of two different elements: the immediate transfer and the deferred transfer. And so today we are asking for the court to enforce the deferred transfer of the 500 gold coins, because wife has demanded payment of that and there has been no payment. Your Honors, the contract is neither vague nor ambiguous. Again, what is owed is 500 gold coins, and when it was due was upon wife's demand. Courts have enforced MAR provisions
Did
with
the trial
far
court
less.
say it was vague or ambiguous?
Not to my knowledge, Your Honor.
Okay.
She was focusing more on the issue of the payment being made at the time of marriage, which was not the case.
Okay.
And there are other courts that have found that MAR agreements are neutral, or are contracts under neutral contract law principles. New Jersey and Odatala versus Odatala found that a MAR agreement was a valid contract where it met standard contract principles. Nuri versus Dadgar, a Maryland court, ruled that the MAR was enforceable as a contractual obligation, and Parbean versus Bari, a Florida court, enforced a MAR agreement as both a contract and a prenuptial agreement. The facts of these cases closely resemble our case, and there's no valid reason for Tennessee to deviate from these well-reasoned decisions. While the strongest argument, in our opinion, is that this case, or that the MAR is an enforceable contract, in the alternative, it should be recognized as a valid prenuptial agreement in Tennessee. Tennessee courts enforce prenuptial agreements when they meet basic contractual requirements. They must be entered into voluntarily, with full knowledge, and without coercion or fraud. And the MAR in this case satisfies all of those elements. It was entered into prior to the marriage. Both parties voluntarily signed the document and were aware of the other party's financial status. And there is no evidence in the record of any fraud or duress that was put upon either party. Additionally, the MAR agreements have been enforced as prenuptial agreements in other jurisdictions, just not in Tennessee. In Shaban versus Shaban, a California appellate court recognized that a MAR can function as a valid prenuptial agreement and should be analyzed under general contract principles. In re Marriage of Dejani, California also upheld the enforceability of a MAR agreement when it was freely entered into before the marriage. And in Ahmed versus Ahmed, a Texas appellate court enforced a MAR agreement as a prenuptial agreement, ruling that it satisfied all contract formation requirements under Texas law. There was no unfair surprise in this case. The terms are not unconscionable, and Tennessee law favors enforcing prenuptial agreements. Randall versus Randall, the Court of Appeals held that prenuptial agreements are enforceable where they are entered into knowingly and voluntarily, and in this case, we meet that criteria.
How do we know that, since there was no hearing?
There was no proof to the contrary, Your Honor, and the parties had an opportunity the day before to negotiate these terms, and they had a day, and then the next day before the marriage ceremony, they both voluntarily signed these agreements in front of the witnesses that were required by the Islamic law.
Do we have some proof in the record of any of that?
Not to my knowledge, as far as what was put before the trial court, no.
Let me ask you one other thing about the alimony. I know you argued it should be higher. What is the proof in the record regarding the husband's ability to pay? Where do we find proof about that in the record?
Your Honor, Mr. Hosseini has a PhD. He is a scientist in artificial intelligence and worked his way up through St. Jude and was making a significant income when compared to my client's very meager income that she was using to support the couple while Mr. Hosseini was obtaining his PhD. There was also proof in the record at trial that this is a long-term marriage. 18 years is a long-term marriage by any standard. And there was also quite a bit of evidence regarding Ms. Shabanian's economic sacrifices, her contributions to the marital estate, and Mr. Hosseini's financial misconduct.
Do we have a Rule 14 affidavit in the record for the husband?
I believe so, Your Honor.
You've not seen it, though, so you can't definitively say there's one in the record?
No, I believe that Ms. Burdett did file a Rule 14 affidavit.
Okay.
Your Honor, we are asking today that the court also look at the fact that husband has refused to meaningfully...
You've used your
Oh,
time.
I'm so sorry, Your Honor. Thank you.
Thank you. Sir, we're going to take this matter under advisement. We're not going to rule today. We'll review the record. We will file a written opinion, and you'll get a copy of the written opinion, okay?
Thank you very much, Your
Yes, sir.
Honor.
Thank you.
I appreciate it.
Yes, sir. Thank you very much.
Thank you, Your Honor.
All right, Ms. Angie, you may call the next case. Y'all good?
Yeah, I'm good.
Judge McGee, you good? Okay.
Poplar Avenue, 1856 Center LLC versus Nexus Exxon